So our today's session is all about patent of addition and amendment of application and specification. So first of all, what do you know about patent of addition? Anyone can explain?
Patent of addition is already you applied for a patent and some modifications is being done, and to that you have to add do the addition for the existing patent application.
Hmm. So any modification or the include? Yeah. Now this is all. So what is the term for the patent of addition?
Already one patent is up for application for one patent, one invention is given. So in that you do some modifications and brings up more, more claims to that. So to have that in the patent of addition is up, is taken care taken up for taken for.
First of all, the patent of addition will file regarding our improvement or any enhancement in the existing patent. Correct. If you are filing one patent application, now that application will be granted, right? Or in the scenario that this is under prosecution stage. And now you are doing research and development for the particular invention. So in that scenario, you have to apply for the idea what you have improved in your existing application. In that scenario, you will apply for the patent of addition. Instead, go for the new application. Right. So, term of patent of addition is similar to that of your main invention. In India, we have a main invention and patent of addition. Suppose you come across the US application. In the in the USA, the main invention is known as the parent application and followed by the child 1, child 2, child 3, uh, likewise. So, patent of addition application.
Ma'am, I remember you telling us about differences between patent of addition and divisional patent application. Can you please repeat that?
Sure. So patent of addition, uh, that is equal to patent of addition you can file anytime after the grant of the patent or the before the grant of the main invention. The term of patent of addition is equal to the term of your main invention. Priority date will be considered from your main invention. Right. Now about the divisional application. So, divisional application filed before the grant of your main invention. You cannot file after the grant of your invention. So in what scenario divisional application will be filed? If your main invention does not have a unity of invention, in that scenario only divisional controller guides to file a divisional application for the set of invention. Suppose you have covered process, product, and process plus product in the same claim set. So in that scenario, controller will direct you that if there is a multiple invention in the one patent, so better you file a divisional application for particular this portion or
Okay.
either process or the product.
Okay.
The term is equal to the same as the main invention, but in the patent of addition, you will not have to pay the renewal fees until and unless your main invention is revoked, right? And for the divisional application is treated as the individual application. In that scenario, after the grant of your divisional application, you have to pay the annuity fees, renewal fees. So this is the basic difference. Addition, you can file anytime before or after the grant, or no need to pay the annuity fees. And for the divisional application, treated as your individual application, and that has to be filed before the grant of your patent. main invention. So under which section divisional application is covered?
16.
Section 16.
16. Correct.
Ma'am, usually it is like when we are talking about antedating, like you told us about section 9(3).
Hmm.
So in that we usually like consider about divisional application, isn't it? But can we consider this patent of addition under that section?
No, patent of addition is not considered as antedating because priority date of your patent of addition considered as a same priority date is of their patent of addition is same as the main invention. But whatever you have claimed in the patent of addition, that is the improvement or the enhancement that will consider from that date only.
Okay.
Got it? Oh. So we'll see the sections one by one. Section 54, that is patent of addition. Subject to the provision contained in this section, where an application is made for a patent in respect of any improvement in or modification of an invention described or disclosed in the complete specification. The file, therefore, in this act referred to as a main invention. So your first application considered as the main invention. And the applicant also applies or has applied for a patent for that invention or is the patentee in respect thereof. The controller may, if the applicant so requests, grant the patent for the improvement or modification as a patent of addition. So you can apply for the new application. The patentee is the same as the same patentee will apply for the patent of addition.
Ma'am, in case like there is one inventor, he has filed for an patent application, and like some other person is coming up with some modification and he joins the inventor, can he file a patent of addition?
Yes, they can file. They can apply for that. But the
Okay.
rights between the both of them considered that is their mutual understanding. Rights of patent of addition.
Okay, so the main inventor has to be there.
Yeah. Main inventor,
The
patentee
applicant.
or the applicant will be that. Subsection 2 says that subject to the provision contained in this section, where an invention, being an improvement in or modification of another invention, is the subject of an independent patent, and the patent in respect of that patent is also the patent in respect of the patent for the main invention. So, suppose there is a two application is filed. First is the main invention. And second is the independent patent. So both the patent is filed by the same patentee, correct? So and both the patent are under the grant stage, or both the patent are granted. Considering that, suppose the controller may, if the patentee so request by order, revoke the patent of improvement or modification and grant the patentee a patent of addition in respect thereof, bearing the same date as the date of the patent so revoked. So in this scenario, suppose let's say your main invention has been filed on 1st of January 2020, and now you have applied for the patent of addition. That is a similar patent applied for the patent of addition on the 1st January 2021. Now both the patent are under the grant stage. So suppose patentee requests to the controller that please cancel my earlier invention, that is my main application. So controller will revoke that, and the main invention, the independent application is the date of the independent application considered as the main invention, date of the main invention. So your earlier main invention is revoked by the patentee itself, and the patent of addition, that is the independent application they have filed. The date of the independent application considered as the main invention's date. Understood?
Ma'am, can you please explain this again?
So, for in this scenario, two application has been filed. First is the main application, and second is the independent application. The independent application is the improvement or the modification of the main invention. So, patentee is unaware like that. Patentee is unaware. He has to find a patent of addition for this. And at the later stage, he come to know that okay, this is nothing but the modification of an improvement of my main invention. Understood this point?
Yes.
Okay. So in that scenario, patentee and suppose main invention does not contain the sufficiency of disclosure, or if patentee thinks that I have to maintain my only single application. So in that scenario, patentee requests to the controller that revoke my main invention and consider my independent patent as a patent of addition, or uh, and that is belongs to the single invention.
But anyhow, ma'am, patent of addition need not be maintained, I guess. You only told that.
Patent of addition now becomes your independent patent. That is your patent of addition. That
Okay.
is now considered as a main invention. But you will get in that scenario, you will get the priority date of your main invention for the patent of addition.
Okay. Like if the main invention is being revoked on sufficiency of disclosure,
Of any for any reason.
for
The
any
main
reason for
invention
that
is
matter.
revoked.
But
So-
isn't this patent of addition dependent on main application? So it can also be revoked on same grounds.
No. That will not like that.
Okay.
If your main invention is revoked now, so your patent of addition is patented equals to the controller, then patent of addition considered as a main invention and treated as an individual application.
Ma'am, all the content and everything of patent of addition is totally different from the main application, we can say?
No, the content of your application is similar. We'll learn on later stage. I think in section 56 described this. Under what grounds you cannot revoke patent of addition.
Okay. Maybe we just narrow down all the claims in patent of addition. That is why maybe
Yes.
it must be approved and the main application may be liable
Considered
to.
as a main application. That
Okay, so we can say that these are narrower claims as compared to main application.
as compared to the main invention, or we can say that will add the enhancement or the improvement or the modification of the main invention. Okay.
Hello, ma'am.
Hello. Yes.
Ma'am, just can you explain the term date of patent once again? Because by these I got confused about that.
Okay. Date of
Date
patent.
of patent.
Date of patent, that means you would like to say the granted date of the patent or the priority date of the patent. Okay.
No, ma'am,
this
as
date of
per
patent.
section 45, I just got confused with your explanation that. Just can you explain one in a one term, what is the date of patent as per section 45?
Section 45. Let me just check section 45 first. Just a moment. Okay? 45. The provision contained in this act. Okay. So date of patent, whatever mentioned in the section 45 is uh, your application date considered as a date of patent. So that is a multiple dates entered in the register. First is your priority date. First, right?
Okay.
Second is your publication date.
Okay.
Right? Now the third is your date of grant. Correct? This
Okay.
main three things registered in the patent register.
Okay.
So whenever your application is granted, let's say after 2 years your application is granted after the filing, but the term of your patent will start from the date of filing. That is
Yes.
considered as a date of application or date of the patent.
Okay.
Okay.
Now, ma'am, in case of patent of edition, my first patent got revoked, or I think you just say that it was not granted, or after grant it was lapsed. Then what will be the date of patent of my patent of edition? Mean the date on which my date of patent, I mean additional patent has been filed will be the date of patent, or the first priority will be taken?
First priority will be taken. Your main invention date considered as your in case your main invention is revoked, and you will request the controller to consider your patent of addition as a main invention. Correct? If
Yes.
controller agrees on this, so your patent of addition priority date should be considered as the main invention date.
No, ma'am, not priority date, the date of patent.
Date of patent. So date of patent, that means the here is the confusion. Date of patent
Priority
and
date.
the priority date. So
Yes, ma'am.
date of patent considered as a after the grant.
Okay.
After the grant of your invention, that is considered as a date of patent. So
Okay.
in the subsection 2, we have discussed about the your first invention is granted. So that is the reason they have mentioned date of patent over here.
Okay. Okay.
So date of patent is your considered, it can be your priority date. It is your priority date, but date of patent terms is used after the grant of your patent. Okay.
Okay.
Ma'am, can you give us any example of patent of addition, like from IP India side? Because I am getting confused on the contents of patent of addition, like how it will be different from the main application. If you have an example, you can just give me the number.
One of my application, I will give you the number after 15 days because it is not published yet.
Oh, okay.
Okay. I can give you my own example, own patents example, but it is not published yet. So probably it will get published by month end or next month.
Okay, okay.
So I will give you for sure. Or meanwhile, if I found some any other application, so we'll share with the team.
Sure, ma'am. Thank you.
Recently, ma'am, we have filed one patent of addition. So what refers, I'll give the glimpse about the invention. So we have developed one tool which is used for fastener fixing into the trim part. Now the inventor is coming up with added just my tool, earlier tool is used for fixing the fastener into the trim part. Now he is coming up with an invention. So why can't my tool can be used for removal of the fastener as well? So everything is remained same. The main components has remained same, but he added one more feature which will incorporate to remove the fastener from the trim pad. So further, we are going to taking the patent of addition instead of going as an independent application.
So the only point is whatever you have, all the content is same. Background of invention, your complete specification, everything will remain the same. But in the complete specification and claim, you have to add the modification part.
Ma'am, can these inventors take advantage of this provision? Because maybe, of course, that is the modification or improvement to the parent application, but they may also come up with something really new and they don't want to pay any fees for that. So they can go for patent of addition. Like,
So
is
this is see,
does
if
anything like that happen?
uh, they can, but see, considering that the invention is not that much like you know important for the company. Suppose we are talking about the company, it's always a business cost to file a patent. So in some of the scenario, yes, they can. In some of the scenario, company just file the application that is known as the defensive publication.
Okay.
Just protect their process. So in the middle stage, if someone comes to them okay, look, you are copying my process. So in that scenario, company will show the proof that yes, see, we have used our own process and we have applied for that. So this is known as the defensive publication. The invention is really not that patentable or the work, but just to file it and the publish it.
Ma'am,
Yes.
ma'am, then under section 3D, can we file, generally my doubt is, can we file for patent of edition? I mean, the inventions which are covered under 3D, can we
Hmm.
file as a patent of edition?
Invention covered under 3D. So
Yes.
if your main invention does not have the novelty, so 3D is related to your novelty, so something new is required for the
I
to
mean, no
overcome.
use, ma'am, no known, new use of a known invention or something it is there, no ma'am, 3D.
Yes, but it has to have an efficacy.
Yes, ma'am. What my doubt is, under that, I mean, 3D, let's give you an example. Take a Colgate paste. It is used for cleaning the tooth. It's the main invention. And when I found that it is also cleaning some stains on the cloth also, then if I want to file and patent, generally it will be revoked under 3D, right?
Okay.
So in that case, can I file patent of edition?
Your main invention is already revoked before filing your patent of addition. So you cannot apply for that.
But in case of patent of edition means which is an improvement of that, no ma'am. So under that, can we,
But
my doubt.
I consider your doubt is if the patent of addition is filed for your live application, that is already in force application, not for the revoked application.
Yes, yes.
Okay. So if your application is already revoked, so in that scenario, you cannot apply for the patent of
No,
addition
no,
because
no,
you have to
ma'am.
go for
No,
the patent of
no,
addition.
ma'am. No, ma'am. My doubt is, first of all, my invention was granted or going to be granted. It is not revoked.
Okay.
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 Let's say an example as Colgate paste used to clean the teeth.
Hmm.
Okay. Next, I got another use of that Colgate paste. Then can I put it under the patent of edition?
Yes, you can apply for that, no? Because you found some improvement. Definitely to remove the stain, you have to change some composition for the Colgate paste, correct? So in that
Yes,
scenario,
ma'am.
you can apply for the patent of addition.
But under the section 3D, it is a new use of a known substance, no ma'am. So can it be revoked or like that? I was getting confused between this 3D and patent of edition.
No, no. Don't
Ashok,
consider it. Don't
Ashok,
correlate the two things over here because it will create the confusion.
Okay.
Just remember that a patent of addition is applied for the improvement or the enhancement of your main invention only. In whatever you have published earlier, that is not considered as a prior art for the patent of addition.
Okay.
Okay, so that will learn in the section 56. That is validity of patent of addition.
Okay.
Okay, so we'll continue with the sections. Subsection 3 says a patent shall not be granted as a patent of addition unless the date of filing of the application was the same as or later than the date of filing of the application in respect of the main invention. Correct? So the patent of addition shall not be granted as a patent of addition. Patent shall not be granted as a patent of addition unless the date of filing of your application was the same or the later than the date of filing of the your main invention. So you can apply for the patent of addition after filing of your main invention only. Subsection 4 says that a patent of addition shall not be granted before grant of the patent of the main invention. So if you are apply for the patent of addition, now the FER patent of addition will prosecute first before your main invention, right? But first your main invention will be granted, and then after your patent of addition will be granted. Okay. Now the term of patent of addition. A patent of addition shall be granted for a term equal to that of the patent for the main invention. So the term equal to your main invention, or much thereof as has not expired, and shall remain in force during that term or until the previous season of the patent for the main invention and no longer, provided that if the patent for the main invention is revoked under this act, the court, or as the case may be, the controller on request made to him by the patentee in prescribed manner may order that the patent of addition shall become an independent patent for the remainder of the term for the patent of the main invention, and thereupon the patent shall continue in force as an independent patent accordingly. So, first says that the term of your patent of addition is equal to your main invention, right? But in case your first invention, that is your main invention, is revoked due to some cases. So in that case, patentee request to the controller. So controller will treat your patent of addition as a main invention for the remainder period. Whatever the period is left for your main invention, for that period you have to pay the renewal fees and consider your patent of addition as a main invention. Now 2 says that no renewal fee shall be payable in respect of patent of addition, considering that your main invention is in force. But if any such patent becomes an independent patent under subsection 1, so in case of your revocation of your main invention, your patent of addition is an independent patent. So the fees shall thereafter be payable upon the same dates as if the patent has been originally granted as an independent patent. So you have to pay the fees for that.
Ma'am, like, can you please explain, like, the controller on request made to him by the patentee in prescribed manner. So what forms are needed here?
Form 30.
Form 30.
There is no form is mentioned now. In that scenario, you have to use the form 30. And mention regarding the section 55. Please consider my patent of addition as a main invention. Due to some reasons, my main invention is revoked. So we have to attach the proof of that also for the applying for this. Okay. Now, section 56, that is validity of patent of addition. The grant of patent of addition shall not be refused, and a patent granted as a patent of addition shall not be revoked or invalidated on the ground only that invention claimed in the complete specification does not involve any inventive step having regards to any publication or use of. So your patent of addition will not be refused or revoked on the ground that the main invention does not have the inventive steps. So the main invention described in the complete specification relating that to. So And the B says that any improvement in or modification in the main invention described in the complete specification of a patent of addition to the patent for the main invention or of an application for a such patent of addition. And the validity of a patent of addition shall not be questioned on the ground that the invention ought to have been the subject of an independent patent. Okay. So no one is questioned regarding your patent of addition on the ground that you have described the same matters that is already been described in the complete specification. You are just getting your patent of addition for your improvement and the modification. That is the new process you have disclosed in your application. Or else everything is remain the same as your complete specification. Now, subsection 2 says that for the removal of doubts, it is hereby declared that in determining the novelty of the invention claimed in the complete specification filed in pursuance of an application for a patent of addition, regard shall be had also the complete specification in which the main invention is described. So, main invention already having the novelty, inventive steps, and industrial applicability or the non-obviousness. So, on the novelty ground, on the novelty ground, your patent of addition cannot be questioned. Main invention is already described the novelty for the particular set of your invention.
So, ma'am, if the main application is being revoked on ground of non-inventive or not having any novelty, then there is no question that patent of addition will be granted, right?
वो पेटेंट ऑफ एडिशन को क्वेश्चन नहीं कर सकते.
Okay. And ma'am,
Because
आपने जो बोला Form 30 का, is there any fee for patent of addition? Because for
Yes.
30, okay.
you have applied for the patent of addition. What is Form 1?
Form
I'll
1
give
is
you a task.
application for patent. Of,
It covers
Yes.
which sections?
Okay, 7, 54 and 135.
4. 135 or 4? Okay. Okay, so you have, if you see the Form 1 now, so Form 1 is meant, I will share demo of the Form 1. किसी ने देखा है Form 1 original?
नहीं.
ये देखा है, just a moment. No. Just 2 minutes. huh? So this is the Form 1. Is it visible?
Yes.
So in that, first type of application you have to mention. Let's say I have filed the ordinary application. Then the name of the applicant for whom you are filing. In the type of your application, you have to mention over here that this is a divisional application or the patent of addition, or the conventional application or the PCT application. You have to click on this. Then you have to mention the applicant's name, then the category of your of the applicant. That is, this is for the small entity. the name of the inventor. So this is the name of the inventor and detail of the inventor. Then the title of your invention. Then describe the authorization of patent agent, service address, and the declaration by the inventor. I think we have discussed these things. Proof of rights at the time of proof of rights. So here they are inventor giving the disclaimer that declaration that the above named inventor are true and first inventor for this invention, and declare that the applicant hereby herein is our assignee or the legal representative. So here the all the inventor give rights to the applicant. So in that scenario, we have to check these conditions also, and then describe your applications, number of pages, and number of claims, and etc. Okay. Okay. I think this
Okay.
doubt is clear for you.
Yes, ma'am.
Okay. So we'll move towards the amendment of application and the specification. So what do you mean by amendment in the application or the specification? Anyone have any idea?
If there is kind of any objection from controller saying any kind of objection for novelty or for inventive step maybe, so applicant may justify that his application is patentable, so he can amend his application accordingly.
Madam,
Maybe
increase your volume, madam. Your voice is low. Your voice is low, madam. Can you increase your volume, please?
Okay. I think you have to increase your system's volume. Hello.
yes, ma'am, you're audible.
This is fine. Yeah.
Yeah, it's okay now. It was better than earlier.
I still having a throat infection, so I cannot speak a little louder. Okay. So basically, amendment is there's a different types of amendments in the application. First, you can amend your application by the controller's order. Suppose in the FER, FER controller guide you that you have to amend your application or your claims basically to enhance your novelty and inventive steps. So in that scenario, we no need to file any form for that, or we no need to pay any fees for that amendment, because you are amending your claims based on your guidance of the controller only. Now, in the case you would like to amend your application, or let's say in the complete specification there is a typo error. So in that scenario, you have to amend that, because that error, that typo error, say आपका जो actual meaning है, that will get you changed. So in that case, you have to amend. After the filing, you realize that this is my error. So in that case, you have to file Form 13 and giving a CDE, that is a correction, disclaimer, and the explanation. In this 3 points, you can amend your application. Okay. So first of all, we see the section 59, then 57 and 58.
One question with respect to the patent of addition.
Yes.
So can I take my improved or modification patent of addition application as a PCT application instead of taking the main application, keeping into the country itself, and I'm only taking the PCT as a patent of addition? Can I take that? Or do you want to take the main invention also to file as a PCT because it's a patent of addition?
I yes, you can take your patent of addition to the PCT, but I need to confirm this because as per my knowledge, you can directly take your patent of addition to PCT. But I will confirm this and will get back to you.
I think you need to give some reference in the
Yeah.
patent of addition, so you can take it, I guess.
Yeah, we can take this. We have to mention the reference, but I just confirm confirm and will get back to you on this.
Okay.
Application, patent of addition. Team will answer this. I will share the answer with the team. Okay.
Okay, ma'am.
So we'll discuss first section 59, followed by 57 and 59. So what is 59? That is supplementary provision as to amendment of application or specification. Subsection 1 says that no amendment of an application for a patent or a complete specification or any document related thereto shall be made except by way of disclaimer, correction or explanation. So after filing your complete specification, you cannot do any changes in your specification. Until and unless you have to give the disclaimer, correction or explanation for the changes. And no amendment thereof shall be allowed, except for the purpose of incorporation of actual facts, and no amendment of a complete specification shall be allowed, the effect of which would be that the specification as amended would claim or describe matter not in substance or disclosed or shown in the specification before the amendment.
Ma'am, sorry to interrupt you, but we are able to see the Form 1 screen only, ma'am. We're not able to see the.
Oh, sorry. Oh, this is visible now?
Yes, we can see the section, ma'am. Yes.
So, as we discussed that after filing the complete specification, you cannot do any changes in your application. But in case of incorporation of actual facts or something is missing in your application, let's say a typo error is there, or we can say the value that is that has been changed, that needs to be changed. So in that case, we have to file Form 13 and giving a disclaimer or a correction or explanation for that particular change. Except the purpose of incorporation of actual fact, and no amendment of a complete specification shall be allowed. The effect of which would be that the specification as amended would claim or describe matter not in substance, disclosed or shown in the specification before the amendment, or that any claim of the specification as amended would not fall wholly within the scope of a claim of the specification before the amendment. So we cannot do a drastic change in that. We can just add or delete the matters by way of the amendment of the application. Subsection 2 says that whereafter the date of grant of patent, any amendment of the specification or any other documents related thereto is allowed by the controller or by the appellate board or the high court, as the case may be. The amendment shall for all purposes be deemed to form part of the specification along with documents related thereto. The fact that the specification or any other document related thereto has been amended shall be published or as expeditiously as possible. and the right of the applicant or patentee to make amendment shall not be called in question except on the ground of fraud. So, whatever amendment you have done, in that scenario, after the grant of your patent, you can do any amendment. So that amendment will be published in the journal, right? So and any interested person can file opposition for that amendment. Right. Subsection 3 says that in construing the specification as amended, reference may be made to the specification as originally accepted. Okay. Any question in this?
Ma'am, what if the controller asks for more proofs or something, like more clarification on any matter that has been disclosed in the original application?
So in that scenario, controller will guide you. You cannot incorporate the things, that is the additional things in your application. But in that case, supporting document you will file with your application on the affidavit, like on a stamp paper that this is the pasted materials, or we can say that this is the experimental data that supports to my application.
Okay. Does Form 13 have this affidavit attached to it?
For the affidavit, we have to file Form 30.
30.
Yeah, Form 30. Now the section 57. Amendment of application and specification or any document relating thereto before consent. Subsection 1. Subject to the provision of section 59. The controller may, upon application made under this section, in the prescribed manner, by an applicant for a patent or by a patentee, allow the application for the patent or the complete specification or any document relating thereto to be amended, subject to such conditions, if any, the controller thinks fit. So, controller will allow the amendments. But in which scenario they will not allow? In case of the infringement suit is going on for your application and the revocation is in revocation suit is filed, and that is in the pending stage. In these two cases, controller will not allow the amendment in your application. So provided that controller shall not pass any order allowing or refusing an application to amend an application for a patent or a specification or any document relating thereto under this section, while any suit before a court for the infringement of the patent or any proceeding before the High Court for the revocation of the patent is pending, whether the suit or proceeding commenced before or after the filing of the application to amend. Okay. Now, subsection 2 says that every application for leave to amend an application for a patent or a complete specification or any document relating thereto under this section shall state the nature of the proposed amendment and shall give full particulars of the reasons for which the application is made. So, if you are doing any amendment in your application, in that scenario, you have to submit the 2 copies. So, first is the clean copy of your complete specification or the claim in whatever you have doing the changes, and you have to submit the marked copy of the of your specification too. And that marked copy clearly shows at which place you have amended. Okay. And the reason for the amendment is clearly stated on the while applying for the amendment in the application by using Form 13.
Ma'am, let's say if the claims are not very well drafted, so can examiner like direct the applicant to amend the claims, and like to what extent the claims can be amended, like the total language can be changed, or how to do it then?
Yes, suppose in the SCR, objection raised, claims are not drafted, or like claim does not show any inventor steps. So in that scenario, the controller raise the objection that please highlight the inventor steps in your claims. So in that scenario, you will completely change the claim structure, what earlier has been filed. But we have only mentioned the matter disclosed in the complete specification. So whatever you have drafted in the claim, it should be linked with the complete specification. It should be there in the complete specification. Then only you can claim that particular part or the process, whatever it is.
Okay, and in case if controller asks for some additional, experimental data, can we like add claims depending on that data?
No, we cannot add on that.
Okay.
So that will goes on the affidavit part. The control inventor is looking at a particular matter, particular experimental data, and inventor is the true and first inventor, and they will sign on that affidavit. And that is the supporting material. But in the rare scenario, controller will ask this. They will take the decision based on your complete specification only. Okay. So we'll see the subsection 3. Any application for you to amend an application for a patent or a complete specification or a document related thereto under this section made after the grant of patent and the nature of the proposed amendment may be published. So if you do any changes in your complete specification after the grant of that specification, in that case, whatever amendment you have done now, that will published on the patent journal or the official gazette. Okay, in this application, this has been changed. Now subsection 4 is when an application is published under subsection 3, any person interested may, within the prescribed period after the publication thereof, give notice to the controller of opposition thereto, and where such a notice is given within the period appointed, the controller shall notify the person by whom the application under this section is made, and shall give to that person and to the opponent an opportunity to be heard before he decides the case. So after the grant of your application, you can do any amendment and your application is published. So after the publication of your application, that amendment part, any interested person can file opposition by using Form 14. And what is the prescribed time? That is 3 months of time from the publication date. They can file the opposition related to the amendment of your application. So in that scenario, controller will notify to the applicant that this interested person is filed an opposition for this amendment, and then it will consider it is continue the case as a opposition matter. So controller call both the parties to be heard and then decide the case. Understood?
Ma'am, why don't they keep just one form for opposition? Like here, it is form 14, then for opposition, there are form 7 and 7A. How many forms are there?
So Form 7 and Form 7A, if you have learned now the ground of the opposition, that will not describe in that in section 25. That is particular on the different grounds of opposition is that. Okay. So this is basically related to the amendment. Now the subsection 5, an amendment under this section of a complete specification may be or include an amendment of the priority date of the claim. Subsection 6 says that the provision of this section shall be without prejudice to the right of an applicant for a patent to amend his application or any other document related thereto to comply with the direction of the controller issued before the grant of the patent. So, as per the controller guidance, you can amend your application before the grant of the patent.
Ma'am, what is it about amendment of priority of the claim?
So, we will talking about the subsection 5. An amendment under this section of a complete specification may be or include an amendment of the priority date of the claim. Let's say you have completely changed your claims while filing the response of the FER. Correct. So, in that scenario, the your claim structure is examined again. So the priority date of your claim is the date of your amendment. Okay.
Okay, so let's say if the main claim, that is independent claim, is amended, then after making these amendments, its priority date will be changed.
Changed. That is considered as the date of amendment. If you completely change your structure of your claim.
Okay, but then
The
again,
priority date of the application is this remaining the same, but the priority date of the claim is changed. That is considered as the date of amendment. You have claimed
mm,
on that day. Okay. Section 58, amendment of specification before appellate board or high court. In any proceeding before the appellate board or the high court for the revocation of a patent, the appellate board or the high court, as the case may be, may, subject to the provisions contained in section 59, allow the patentee to amend his complete specification in such manner and subject to such terms as to cost, advertised or otherwise, an appellate board or the high court may think fit, and if any proceeding for revocation for the appellate board or the high court decides that the patent is invalid, it may allow the specification to be amended under this section instead of revoking the patent. So suppose, let's say, your application is under the revocation proceeding. So there is a different ground of the revocation. In any of the ground, your application is proceeding for the revocation. So in that case, appellate board and high court will not directly revoke your application by stating this is not contained the prior. Let's say one ground of the revocation is not having the prior not having the inventive steps of your application. Let's say. So in that case, the appellate board or the high court will not directly revoke your application. They will give you an opportunity to amend that claim to highlight the inventive steps features. right? So you can amend your application before the appellate board or the High Court. Now the subsection 2 is when an application for an order under the section is made to the appellate board or the High Court, the applicant shall give notice to the application to the controller. The controller shall be entitled to appear and be heard and shall appear if so directed by the appellate board or the High Court. So in case of any amendment is done in your application, so the High Court or the appellate board give the notice to the controller. Let's say this is the amendment done in the application, and the controller will heard the applicant. That this is basically describe the hearing part. The hearing happens. Hearing will be done before the deciding the case. Now subsection 3 is copies of all orders of the appellate board of the High Court allowing the patentee to amend the specification shall be transmitted by the appellate board or the High Court to the controller, who shall on receipt thereof cause an entry thereof and reference thereto to be made in the register. So any amendment done at the time of the appellate board or the High Court, so that will registered by the controller in the patent register. And a copy of the amended specification is transmitted to the controller for mentioning in the patent register.
Ma'am, could you give me some more explanation about amendment of specification before appellate board or High Court? When it will exactly rise during the.
Suppose, okay, I'll explain. Forgot all these 3 things. I just explain you like that. Suppose I have applied for one application. My patent is granted. Now, under one of the revocation grounds, my application is under the revocation process. So revocation will happen in the appellate board or the High Court, because there is a case is going on, lawsuit is going on for your application. Understood?
Okay.
Correct. Now, let's say you argue with that. Okay, I will amend this part because this part having some problem. So this is the main part. There is a problem for my revocation of my patent. So I will amend this part. Correct?
Mm-hmm.
Now, suppose I am amending that part. So High Court has to notify to the controller, patent controller, let's say for this application or for this specification, this part is amended. So they call upon to the controller, and controller perform the hearing to the applicant. Why you in what stage you want, in what state of mind you have to amend your application. Correct? So
Okay.
after the hearing of the applicant and the controller, they were satisfied that okay, let's say amend this application. So revocation will not happen. Right. So in that case, they will amend the application. The applicant, who is the applicant, they will amend the application. Now, whatever amendment you have done in your specification, that has to be transmitted to the controller. Because controller has to mention these things in the patent register. So your application is not revoked.
Mm-hmm.
Sorry. After just a moment. Your application is not revoked. You can amend the application and your application is survived. Got it?
So, ma'am, we can say like amendment is kind of narrowing down your claims, right?
Not
Is it
exactly
like that?
Not exactly narrowing down the claims. Suppose there is unwanted matters are mentioned in the claims. Like if you are starting with the claims now, the invention claimed in the above proceeding claims 1 to 10. Suppose you are writing the 11th claim. So some of the controller will not allow this language, all of the proceeding claims. So that will has to amend. Okay. Or if in case you are writing that you are using about 5% to 10% of alcohol. So either you can use 5 to 10% of alcohol, but cannot use the word about. So some of the patent agent or some of the person having the habit of mentioning the about word before the range. So that is not allowed by the some of the controllers. So we have to amend that part also. And
So it totally depends on the controller then, like
yes,
if he is allowing or not. So
yes,
it
yes.
will depend on controller case
That
to
is
case.
on the case to case basis. Amendment is valid.
I think in the prosecution, the claims amendment is totally depends upon the examiner point of view. What the
Yes.
examiner is looking after reply application to see any typo or
Hmm.
your preamble is not matched with the title, or he may suggest the like comprises characterizing thing. He will
Yes.
give some suggestions to amend your claims without disturbing the novelty and inventive step of your claims.
Correct. Correct. So that completely varies on a case to case basis.
I mean, I don't know, like I'm right or not, but if any examiner is doing all the analysis of whatever contents
Hmm.
are there, I think he should only take the decision. Like it should be allowed or not, because controller will be a totally different person to put his thoughts on this. I don't know
See,
how
examiner
fair is
is
that.
because this is a completely different topic.
There could be one more option called voluntary amendment, like where
Yes.
the patentee can add the information or the proof to support your claims. You can amend your application as a voluntary amendment just to support your invention. Like as you mentioned, give some data or examples or the improvement perspective. All this information you can add it into your application. That is called voluntary amendment in your because
For
examiner is
that,
not cited.
for the voluntary amendment, you have to that is described in the form 50, section 59. That is by doing the disclaimer, explanation or correction.
Mhm.
You can add the actual facts.
But if examiner is not asking it, why to do?
That depends on case to case basis. If you really wish to add this, then you can.
Again,
Examiner is not
examiner
asking,
may
then
again raise some objection that why are you providing it? I am not asked.
No, 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 no. There could be some of the cases you are adding the information which will be easily understanding to examiner also. You are just giving the, because at the time of drafting the application, so they may be in the specification you wrongly mentioned, or you are not fulfill this spec as a complete manner. So at that time, during the development of your invention, you understand that this information needs to be incorporated in the specification. It will be value added to your application. So at that time, you can amend voluntarily to support your invention.
Okay, so you're saying that before raising any objection, like if any FAR is allotted, you can do all these amendments voluntarily, right?
But what happens when a first examination report is issued? After that, any amendment is allowed?
yes, they will amend.
I'm telling that after the examination only, because
Okay, after
examiner
examination.
is examining the application. At that time, you feel that so this information also will be added into the specification. It will be give the strengthen to my application. You can add that, but ma'am, you can confirm me. I might be wrong. Uh, Before not done the examination, can we amend the application as
Yes,
a
we can we
okay
can amend the application before that also. But
after the
in that
publication?
scenario, after the publication, you can amend the application.
And
But
how to do it? Like again, we have to. Uh,
so for the procedure is like we have to file a form 13 for that, and clearly stating that we would like to amend this part, or in that scenario we have to submit the 2 copies. Uh, any noise is there? Please mute your mic. Hello. Yeah. Thank you. So in that case, you have to give the clean copy and the marked copy of your specification, or the part, whatever you are amending.
Okay, before examination also we can do the amendment of your specification as well as claims, ma'am. Both we can do
Both can be done.
without disturbing
But,
the novelty and the inventor step. Okay.
Yes, I'm saying this only without disturbing the novelty and the inventive steps of your specification. So basically, it will not happen. Generally हम ये करते नहीं है, but just typo error हो या ऐसा कुछ हो तभी जाके हम amendment करते हैं. बाकी once you file the complete application ना, उसके बाद कोई amendment नहीं करता है. On the rarest scenario, we have to do this.
नहीं मैम, जैसे अभी एक एक्सपेरिमेंट कर रहे हैं एंड मीनवाइल वी आर आल्सो फाइलिंग दिस पेटेंट एंड और एक्सपेरिमेंट में हमको और कुछ अच्छे रिजल्ट मिल गए थोड़ा मॉडिफाई करके एक्सपेरिमेंट, तो हम वो एक्सपेरिमेंट ऐड कर सकते हैं क्या वर्किंग एग्जांपल के फॉर्म में बिफोर इट गोज बिफोर वी गेट एनी FER?
See, I can suggest, okay, if you get a good result now for your next experimental data, so you can file the patent of addition instead of amending that part.
That's the correct way, madam. You can file patent of addition rather than amending it.
Amending the application, because do
That
not
way you
do not disturb your scope of your application by amendment. In some of the cases, it is really good. After the FER, whatever amendment you are done now, that is always beneficial, because controller will examine that. After the first they have examined your application. After the amendment, they will again examine their application, and whatever facts you are providing now after the examination report. तो वो फैक्ट्स जो रहेंगे वो कंट्रोलर के लिए कंट्रोलर के समझने के लिए आप करोगे फॉर द इजी अंडरस्टैंडिंग ऑफ द कंट्रोलर. So I would suggest go for the after the examination report, amendment after the examination report. और अगर कोई क्वेश्चन रेज नहीं कर रहा है कंट्रोलर उस टाइम पे भी, तो मत करिए कुछ भी. Okay.
No, ma'am. What she was mentioning is when you were filing an application, at the time you have the composition data only. You are coming with an invention with a composition, and you filed it.
Okay.
And the experiment results taken, and to find out the technical benefits of your composition, it will take some 1 year or 6 months timeline to get your experiment results. So can I?
That is why the first file provisional application, na? And then file the complete application. If you are not feeling that your invention is not completed yet, so in that scenario, file a provisional application.
No, ma'am, I can go with, I have the full information, but only the technical benefit information, I didn't have it. I can go and file it as a complete specification itself.
So
But
after that, you can add that actual facts.
yeah.
That is the actual facts of your application now, so you can add by way of the amendment.
Okay.
Ma'am, in case if we are filing a provisional application and within 12 months we also file complete specification, okay, this is all done and the application is yet not published. And meanwhile, if we, that is what I wanted to ask, like, meanwhile, if we find any good results or anything like before completion of 18 months of publication, and that we have not even filed this request for examination, okay? So can we edit our application during that time?
Once you file your complete application, so you can add the results, but you cannot disturb the scope of your invention.
Okay, so we cannot pile on whatever is present, right? What
So-
is done is done. We
Done.
just
So
need to
first
go for
file a
patent of addition
patent
or
of addition only.
okay.
Because once you file complete application, nothing will be changed in that. You cannot change single word. But what I have said now, the amendment is like for the typo error or the adding the facts in. Okay.
But one of the cases also I'm getting it.
Hmm.
So we have filed an application, complete specification, we filed it. And
Hmm.
after 2 months, we realized that the title is not suitable for my application. Can I amend the title? Before just we have filed an application 2 months. Last
You
2
have filed
months.
a provisional application or a
Complete
complete application?
specification. Complete specification we filed.
specification.
Yes. Yes.
You cannot change your title. You
Okay.
can change your title at the time of FER.
At the time of FER, I can amend the title.
Amend the title. Yes.
Okay.
But we have to request the controller. If controller is not giving any direction at that time, if controller thinks that your title is not appropriate for your invention, at that time you can amend that, or if you really wish to amend the title, then by filing form 30 you can amend. You request the controller for this.
Now we can't have any authority to change the title for your application. Only during the examination time only the applicant
Yes.
can amend the title.
Yes.
Okay.
Madam, when the title needs to be amended, it has to direction has to come from the controller, is it not?
Yes. Yes.
Rather than the applicant himself.
Voluntary, we can do that, no? If applicant wish to change the title, so they can, but they have to request the controller for this by paying additional fees and this, and providing the proper explanation why you really wish to change your amend your title.
If the controller sees satisfactory title, then what is the need for amending the title?
That varies from the case to case. No? The applicant wish to amend, then they can, or controller controller is okay with that title, then that depends on the.
Sir, I'll give my explanation for that, sir. What I feel, why I want to change my title of the application is earlier application, the title which you have filed, it's very generic and general, and the controller may find easily prior art to that, and there will be a lot of available prior art which is talking about the generic title which I mentioned. Now I am going to the specific application and the specific invention. So that's why I wanted to keep the title with respect to my invention. That's why I want to amend the title instead of keeping the generic and very broad title.
Can you give us a concrete example for this, Mr. Shanta?
So I'm coming up with an invention called a parking brake. So my title of the invention is just parking brake vehicle, parking brake for a vehicle. This is very generic, which is existed for so many years. But actual invention is talking about mine as a collapsible parking brake mechanism. But I made the title as a parking brake.
Okay, I got your point. You will get the prior art related to this. But you have mentioned prior art is not basically searched by the only by the title. It will search by your abstract field.
Correct.
And from the claims field. So whatever method you have disclosed in that now in the main claim 1. So based on that, you will get the prior art.
Correct. Exactly. Title doesn't define your prior art.
Correct. But what we feel is, sir, we have to because it's a when reader perspective, if you see that invention, this invention belongs to vehicle parking braking assembly, vehicle parking brake. But actual invention is not talking about the parking brake, but it's talking about the something else what we developed.
Okay.
No, it is pertaining to parking brake only, right?
Yes.
Then your title of parking brake is absolutely correct.
Correct. What I can understand as a patent
this is
site to confuse the people or confuse the examiner without easily
Hmm.
finding the reference. We put an application in a very broad manner, because to confuse the inventor, we cannot give the direct hint to the controller to find out the easily references. To just give the work to them, we have made the invention in a broad manner. It will cover the main braking as also the collapsible braking system.
Shantan,
Yeah.
you cannot, you can fool someone for some time, many people for some time, but not all the people all the time.
Okay, then. So now we are moving towards the rules. That is 81, 82, 83 relates to the amendment of the application. So rule 81, that is amendment of application specification or any document relating that to. Subsection 1 says that an application under section 57 for the amendment of an application for a patent or a complete specification or any document relating that to shall be filed, shall be made in Form 30. So you have to use Form 30 for the amendment. If the application for amendment under sub-rule 1 relates to an application for a patent which has not been granted, the patent shall determine whether the subject to what condition, if any, the amendment shall be allowed. So the similar way, if controller thinks fit, then they will allow in case of the application is not yet granted. Subsection 3 is sub-rule 3, sorry. It says that if the application for amendment under sub-rule 1 is made after grant of the patent and the nature of the proposed amendment is substantive, the application shall be published. So after the grant of your application, grant of your patent, whatever amendment you have done, that is published. Now, any interested person interested in opposing the application for amendment shall give a notice of opposition in Form 14 within 3 months from the date of the publication for the application. Please remember this for the publication of the amendment of the application. That opposition will be filed by the any interested person only by using Form 14 and the prescribed fees and within 3 months from the date of the publication. Please remember this timeline. C says that the procedure specified in rules 57 to 63 relating to the filing of written statement, reply statement, leaving evidence, hearing and cost shall so far as may be apply for hearing of the opposition under section 57 as they apply to the hearing of opposition proceeding. So the opposition proceeding is the same as the described in the rule 57 to 63, that is filing the written statement, then the reply statement within the 2 months of time, then the living evidence and followed by the hearing process. So the whatever opposition is filed under this rule by using Form 14, that will the opposition proceeding with the same as the opposition filed for the rule 57 to 63. Okay.
I'm sorry to interrupt, but I just wanted to confirm one thing. Like, if we are filing a provisional specification and following it by complete specification, no, sorry. If I'm antedating my application, what forms are there?
Sorry, you are
If-
antedating.
If a complete specification is filed and we are converting it to
Provisional
provisional,
specification.
then what forms are there?
Just a moment. I just need to check once.
Is it Form 13 that we because we are
No, not the Form 13 is for the amendment. We have to use Form 30, I think. 30.
okay.
Yes. Form 30. When there is no form prescribed now, at that time we have to use Form 30.
Okay, so there even the fees are not mentioned there. for Form 30. So we cannot tell like what fees will be applied, right?
I think there is no fees for the antedating of your application.
Okay.
Yeah, there is no fees. Just because Form 30 will be filed with fees and without fees too. Okay. Coming to the rule 82, that is preparation of amended specification, where the controller allows the application for a patent or the complete specification or any other document to be amended. The applicant shall, if the controller so requires, and within the time to be prescribed by him, leave at the appropriate office an amended application or the specification or the other documents, as the case may be, in accordance with the provisions of this rules. So, if the controller guides you for the amendment, so in that case, the controller will give you the prescribed time to submit the amended copy of your application. So you have to fulfill that requirement. So let's say in the FER, controller guide you to highlight your inventive steps in the claim. So what is the time period for filing a response of FER?
Um, 6 months, I guess.
Yes, 6 months from date of issuing of the FER. So within 6 months of time, you have to fulfill that requirement.
There is also form for extension of time. So we can take the 3 months
Extension.
timeline too. Yes.
Yes, 6 plus 3. So rule 83, that is publication of the amendment allowed. The amendments allowed after a patent has been granted shall be published. So whatever amendment done after the grant of your patent, that shall be published. Okay. So, any question in this?
Whatever changes happens, whether it's amendment or some this thing, that immediately goes into publication, right? After the consent.
As expeditiously as they will publish that amendment. So now we'll have a question answer session. My screen is visible to you?
Ma'am, can we fasten the process after the FER is allotted, like within 6 months? If I'm willing to, respond to FER within 1 month, so can the controller also respond me back as fast as possible?
No, controller will not respond you back as early as possible. Controller will take their own time to respond. Only in the case of if you find an expedited examination, in that case, in that scenario only, controller will issue the examination report as within 3 months of time.
Okay.
Or else there is no provision.
So response to FER is not necessarily responded fast.
Yeah, but in that scenario, if you file the early response to your examination report, there is a queue of the examiners or the controllers. So your number will getting as early. Like जब आप जल्दी फाइल कर दोगे तो आपको जल्दी रिस्पॉन्स मिलने का चांसेस है.
Okay, okay.
So there is number allotted to the each examination report. Okay. Hope my screen is visible to you. That is the questions.
No, it's still the patent rules.
Patent rules. No? Okay. Stop sharing this. So here is the few questions related to today's session. So first question is, patent of addition applied for?
Improvement or modification?
Correct.
Improvement or modification?
Yes. So answer A is right. Improvement or modification when apply for the patent of addition. Second question is main invention filed on 3rd March 2013 and patent of addition filed on 3rd April 2018. Now the main invention is revoked, considered patent of addition as a main invention. What would be the
B.
date of patent of addition?
B is the answer, ma'am.
What is the date?
B. Answer B.
Okay, B. Before
B.
correct. Now the next question is true and false. A patent of addition is granted before the grant of main invention.
False.
False, madam.
False.
False. False.
Okay. Now the fourth is again true and false. Renewal
False,
fees
madam.
must be
False.
paid for the false. Okay. And suppose your main invention is revoked. So in that case,
Yes, fees will be applicable then.
okay. Sorry. So now question number 5. The priority date of main invention is 1st January.
Ma'am, regarding fees, yesterday actually we had this in our lecture, but like for paying the renewal fee, end of the second year something was there.
Yes.
But like if I'm filing my patent on say 1st January 2018, and so the fees will be applicable from 1st January 2022. Is it okay? Is it correct?
No, it is, suppose you have filed, the application is 18 now. So the fees will be start from after the 2 years. So we have to pay the advance fees, correct?
Okay.
So before the end of your second year, you have to pay the renewal fees for the 3rd year. So you have to pay the fees on 1st January 2020.
Yes, that is what.
Okay.
So even if the patent is getting granted after 4 years, let's say on 1st January 2022, still I'll have to pay fees
From
from
20.
1st January 2020,
Correct.
right?
From the
So
20,
for
yes.
first 2 years, we do not have any fees, right?
Yes, right.
Okay.
Correct.
Your renewal starts on a 3rd to 20th year.
20, yes.
Yes,
Correct.
I also like saw this on the certificate of patent that we get. There is mentioned some date on which you need to like
Pay the renewal
go
fee.
for fees on
Yeah.
that date, right?
Yes.
Okay.
Correct. Okay. Yeah. So moving towards the question number 5. The priority date of main invention is 1st January 2018 and that is granted on 13 June 20. The patent of addition is filed on 7th July 2020 and granted on 4th November 2021. What is the term of patent of addition? Considering main invention is not revoked.
11/2038, madam. 11/2038.
Correct, Mulidaranji. And what if your patent of main invention is revoked? So in that scenario,
It will be the same, madam.
Same.
Same.
then so you understood the concept clearly. So what are the criteria for amendment in application?
Main criteria is improvement or modification should be there.
Amendment.
Amendment is correction.
Correction. Okay.
CBE.
Correction,
CBE.
disclaimer, and explanation.
Yes, explanation.
Clerical errors.
Yes.
Mhm.
You can add the actual facts only at the time of amendment. So basic criteria that has to be fulfilled: explanation, disclaimer, and the correction.
Ma'am, in your previous lectures, you told us like 5 things are really important when we are answering to any questions: form, fees, section, rules, and 5th was what?
Timeline.
Timeline.
Next question is which form is used for the amendment
On 13.
Form 13.
and what would be the fees of that? Please check in the book.
Form 13 or ma'am? Form 30.
13.
13 is good.
300 says for natural person.
मुझे भी देखना पड़ेगा. Form 30. No, that is 800 before the grant and 1600 after the grant. And 1600. 800 for the before grant and after grant it's 1600. For the natural person or the small entity or the education institute.
Oh, so we can also change the name and address or nationality.
Yes.
Okay, so that for that it's 320.
That is mentioned in Rule 94. I think we have discussed Rule 94.
In the
Yeah.
schedule itself, they have given, madam. In the schedule itself, they have given what is to be done, what is the fees to be paid before grant and after.
Rule 94 is alteration of address. Okay, that is in the register of patents. So at the time of the changing your address, you have to face this alteration of address in the patent register.
So ma'am, if any person is if say if there is one inventor, he files a patent and after that he feels that maybe he needs a patent agent, can he appoint him after that?
Yes, they can
Like any time after
at any
filing it?
stage of the filing.
Okay, so at that time maybe this will be important, right? Alteration of address.
Alteration of that. No. Alteration, that is a different. For the amendment, that is before the grant. Let's say they appoint this person, the patent agent. So they has to pay the fees 800 rupees because they have to change in the Form 1. That is this portion of change.
Oh, so again they'll have to file a Form 1.
Form 1 again they have to file. Where is it?
So again, like 1600 we have to pay.
1600
Form
you have to pay for the authorization of the patent agent and the power of authority. That is Form 26.
Oh.
Okay.
And in case if we want to remove the patent agent,
Then again you have to file a Form 1.
again like 1600. But we are not filing any application. We are just changing the name.
So you are doing the change now. The address you are change the service address and the number and the email address. So at that time you have to change this point. Because patent agent mentioned their own email ID and the number, contact number. So you have to change that. So in that case, we have to file Form 13 for the changing in the this service address or etc.
Oh, so Form 13 plus Form 1 both.
Yes, both has to file again. Okay. Now the question 8 is amendment can be done before the grant of patent only.
False, madam.
False.
False.
Okay.
Because after grant of patent also can be done.
Okay, done. And it is published. And any interested person can file opposition by using Form 14. Question 9. Which form is used while filing opposition for amendment?
Form 14. Form 14.
Okay. And what is the fees for that?
2,400, madam, for individuals. 6,000 for entity other than individuals.
2400.
Yes.
2400 for the individual and 12,000 for the large entity.
Yeah, larger. 6,000 for smaller.
No, not 6,000. It's 2,400.
2,400 for individual.
2,400. Yeah. Now the next question and the last question is this. Who can file opposition on amendment after the
Person
grant?
interested.
Person
Person
interested.
Interested.
Okay. So I have given you a task on a last Sunday, I think, to remember section 1 to 25 or 21. कितना दिया था मैंने?
25.
25, no? So, if possible, everyone, please switch on the video. So I will ask you a question on that. So I can understand.
Madam, my video is an issue, madam. My camera is a problem.
Okay, no problem. तो मैं आपको क्वेश्चन कर रही हूँ कंसिडरिंग दैट कि आप बुक में से आंसर नहीं करोगे यू नॉट आंसर फ्रॉम द बुक
Yeah.
ओके 1111 what is section 11
Section 11.
yes
Publication.
no
Priority. Section 11 is priority date of claims of complete specification.
correct Saloni. My favorite number 13 1313
Search for
Search for-
anticipation.
correct section 6
Persons entitled to apply for patents.
now 24
24. It's not there.
It's omitted.
correct now number 3
Non-inventable.
Non-patentable inventions.
correct 16 16
Divisional.
Power of controller to make orders respecting division of applications.
correct 20
A substitution of applicants.
okay now
Control.
form
To make substitution of it.
okay and forms मैंने 1 to 10 कहा था ना
Yeah, madam.
yes form number 8 form number 8
Request for mentioning of inventor
correct
under section 28.
form number 2
Complete
Provisional
specification.
and complete.
Provisional and complete specification.
and section and rule
Section
It's 9.
no
Section 9
no
for complete and
no, section
what form to describe form 2 we are using for filing the complete specification and the provisional specification so what it meant so we are used the section 10 for that contained of the specification
Right.
form number 5
Declaration.
Declaration of inventorship.
declaration of inventorship. Rule number 13(6). madam.
okay now form 1
Application for
What is
grant of
application?
patent.
and which section
Section 754 and 135.
Section
And rule
7 and rule 11.
21.
correct and what is the name of the form 1 the second name of the form 1
Madam, can you repeat the question?
what is the second name of the form 1 what we call form 1
Ordinary application.
Proof of right.
Correct. Proof of right.
What is
Form
that,
1
madam?
is also known, Form 1 is also known as proof of rights.
Proof of right. Okay.
Form 10,
Then
that is Kashmira ji and Gitali ji.
It is for amendment of patent.
And rule 1 to 16 I have given to you now. Rule 1 to 16 I have given you for the mother. Rule 16.
Models, it's related to models, which is mentioned under section 10.
Correct.
Mm.
Now, rule 5. Rule 5.
Address for services.
Correct. Rule 10.
Proof of right, which is mentioned under section 7.
Correct. Now, anyone explain section 3?
It is about
Section 3.
inventions that cannot be patented. Section 3A is for frivolous inventions. Second is for which go against the human morality. C is for natural.
Correct.
Make sure.
Natural laws and scientific principles.
Okay. D is for discovery of new form of known substances and related to salts and metabolites, pure form. Then E is for mere admixture.
F is for arrangement or rearrangement of
Rearrangement of.
Substances.
G is no more there; it's omitted.
omitted. Yeah.
H is for horticulture related
Agriculture.
inventions. Their devices can be patented, but the process cannot be. And I is for medical, surgical, curative, prophylactic, diagnostic related patents. There again, the devices can be patented, but processes cannot be. J is for plants and animals except microorganisms. These cannot be patented. K is for mathematical method and business method, computer program per se. Okay, L is for literary work, that is copyright or artistic work. M is for here schemes or mental act.
Mental act.
N is equal to
N is,
mental act.
yes, N is presentation of information. And O is topography of
Business model.
integrated circuit.
Business model.
P is for
Business model.
traditional knowledge.
Total we have 15 subsections in section 3.
A to P.
A to B ground. And anyone remember the opposition ground?
Yes, first is for wrongful obtainment A, then B is for B.
Priority date of claim is
Right. Prior claim, prior publication. Third is prior claim.
Traditional knowledge.
T is for this thing, public use and knowledge. E is for inventive step. F is for novelty.
Okay, yes.
And G is for disclosure related insufficiency of disclosure. H is
related to section 8.
right. Proof of right. No.
Foreign filing
Foreign
regarding
filing.
And undertaking. Form 3.
section 8.
Then intentional non-payment of renewal.
No,
That is different.
no, that is not a ground.
That is different.
I is for in case convention application was not filed within 12 months.
Okay.
I think we have to take some tips from Saloni. She is telling very fastly how she is able to remember.
So there is regularly, you have to mug up the section daily, so it will easily understand. So
Okay.
मैंने ये prepare किए थे sections at the time of my examination 2018, but still मुझे याद रहता है, मतलब याद है अभी तक मुझे. But it gradually goes into your subconscious mind. Suppose anyone says that what is section 13, so you can, okay, this is related to anticipation, right?
Understand. Like we have remembered the formulas for a plus b whole square is this thing. We have
Yes.
read it in childhood days, but still we have the remember.
Remember the thing.
Yeah.
Yeah. Well, likewise,
Repetition is important.
repetition. Yes. Revise daily.
Sure, ma'am.
Okay.
I is for international application
Hmm.
related. IJ is for I think biological material. The source is not given or something.
I have to check
K is for traditional knowledge. So for all section 3, second 25 K, and for 3 it's N. It's for traditional knowledge.
Hmm. Hmm. Okay.
Last round.
Correct. Anticipated having regards to the knowledge. Correct. Okay. So for the next session, the task is from section 25 to 42. And form 1 to 15. And the rules, just a moment, rule. The PCT application is completed or not?
Not yet.
Oh, ma'am, not yet.
Okay. So we'll give you the rules from chapter 4 and chapter 5. Chapter 5 is omitted, chapter 6. So rule 24 to 70. In between 39 to 54 is omitted. So rule 24 to 70. I just mention in the chat box.
I mean, situation-based question, can they ask for amendment of any specification? As such, if you are a patent agent, then
So,
go for amending this application. Likewise.
So in the case they may ask, but अभी तक के जितने भी पेपर्स देखे उसमें ऐसा कुछ दिखा नहीं है. जनरली उसमें से जो क्वेश्चन आ रहे हैं वो एमसीक्यू क्वेश्चंस ही आ रहे हैं ये दो चैप्टर्स में से. पेटेंट ऑफ एडिशन से ये चैप्टर आ सकता है, आपको क्वेश्चन आ सकता है फॉर फाइलिंग द न्यू एप्लीकेशन फॉर द मॉडिफिकेशन that can be asked in the situation based question.
Okay. And ma'am, in Viva, can they ask any question related to this?
Probably not.
Okay.
Because Viva में आपका बेसिक नॉलेज चेक करते हैं वो जनरली. 1 to 42 section.
मैम मतलब मेरे पहचान वालों ने बताया कि वाइवा में बहुत खींचते हैं क्या?
हाँ, जैसे हमने कॉलेज में वाइवा दिया है ना, एक चीज को ले लेंगे, इसको छोड़ेंगे नहीं. that depends on that varies. मतलब इतना कुछ प्रॉब्लम नहीं होता क्योंकि हम we all are from the science background, so we are habituated with the वाइवास.
हम अगर कॉलेज डेज में वाइवा में आंसर नहीं देगा तो मार्क्स देता है, बट इसमें
कोई भरोसा नहीं.
So that is the reason we have to cover maximum marks in paper 1. We have to score 80 plus in paper 1 and in paper 2 60, at least 60. तो आपको वाइवा में आपको क्लियर करने के लिए 150 मार्क्स चाहिए. So you have covered 80 plus 60. So 130 and 20 marks तो दे ही देंगे वाइवा में.
मैम वाइवा में कितना पासिंग होता है?
वाइवा में पासिंग मार्क्स नहीं है.
ओह, तो पुअर परफॉर्मेंस रहा तो 0 भी मिल सकता है.
इतना तो हम इतना खराब तो हम नहीं करेंगे. सपोज हमारा दोनों पेपर अच्छा है तो कोई प्रॉब्लम नहीं. नॉट टू वरी अबाउट वाइवा. ओके.
वाइवा कौन कंट्रोलर्स लेते हैं क्या?
कंट्रोलर्स भी होते हैं और एग्जामिनर्स भी हो सकते हैं. जनरली कंट्रोलर्स भी होते हैं.
What is the minimum marks safer to obtain in paper 1, madam?
Sorry?
What is the minimum marks safe to get in paper 1?
For in the paper 1 you have to score 80 plus.
80
So your
plus.
target to cover maximum marks in paper 1.
Paper 1. Okay.
So what you can do now, आपको जब भी पेपर 1 आपके पास आता है तो directly don't goes into that OMR sheet. You know the answer now, so you have to write in your paper.
Okay.
Do not directly tick mark in the OMR sheet.
Okay.
And again मतलब you have sufficient time, so आपको 2 बार वो पेपर क्लियर करना. 2 बार आप पेपर चेक करने के बाद ही आप उसको वहां पे टिक मार्क करना.
वहाँ पे पेंसिल से नहीं चलता ना?
नहीं, पेंसिल नहीं, ब्लैक पेन ओनली. तो आप OMR में आप चेंज नहीं कर सकते कुछ भी. So better to do first, solve your paper first in the paper itself, and then again at a time of marking check your paper again. उस टाइम पे मेरे 20 marks at my time I share my experience. मैंने 20 mark का गलत टिक किया था मेरे पेपर में ही.
Oh.
So at the time of actual tick mark ना, so at that time I realized, oh sorry, I did this.
वो भी तो पता चलना चाहिए ना मैम, गलत टिक किया है.
नहीं, वो हो जाएगा, हो जाएगा, हो जाएगा. Law is always like a second thought. वो हो जाएगा. Done.
Yeah, ma'am. Yeah, ma'am.
Yes.
No, sure. What you have said is 100% right.
It's always a second thought. That is.
So next class, ma'am, section 1 to 42, rule 24. Rule 24
Rule
to
24 to
70.
70 and form 1 to
1 to
15.
5. Okay.
1 to 15.
Yeah.
Okay. Done. And with this, please remember the timelines and the fees too. And one more I would like to share.
Ma'am,
What is the definition?
one of my friends during Viva was asked like, एक minute, I need to. आप मैम आप कंटिन्यू करिए, मैं पूछती हूँ.
What is the definition of inventive steps?
Means non-obvious to the person's field in the.
It's a feature of your invention which is having technical advance.
Economically significant and non-obvious to the person engaged in the.
Correct. What is a person interested?
Person interested is a person who is in the research of the same product or a process, or the person who is making the same product or similar product elsewhere.
Person which is in the same field.
Person engaged in promoting or in research.
Yes, ma'am. उसको पूछा था कि in case आप engineering background के हो and if you get an inventor who is from biological background and want to go for patenting it, then would you patent it? I mean, would you draft any complete specification? So as far as she told me, उसने बोला था कि नहीं मैं नहीं करूंगी पेटेंट ड्राफ्ट उसके ऊपर बिकॉज वो मेरा फील्ड है नहीं. सो ऐसे टाइम पे फिर क्या आंसर देना चाहिए आइडियली उसको वाइवा में कम मिला था, जहाँ तक उसने मुझे बताया, तो वो रो वगैरह रही थी। बट वही उसका ही डर बैठ गया है मेरे मन में कि अगर ऐसे भी आंसर देते हैं तो फिर कैसा, क्या
No.
बोलना चाहिए।
In some of the cases, they will check your confidence. Right. So how confident you are for being a patent agent to address your client. Suppose from the pharma background client comes to me and they want to file an application. Yes, I'm doing that. I will do that. Then again, the controller will question this. You are from the engineering background, so would you be able to perform the pharmaceuticals invention? So in that case, you have to answer that. In the Patent Act, nowhere there is mentioned that engineering background वाला engineering का ही ले सकता है या फिर काम कर सकते हैं.
नहीं,
So
बट
this
मैम
is
हम जब पेटेंट
basically,
एजेंट के लिए भी एग्जाम के लिए फॉर्म भर रहे हैं, उसमें तो अपना बैकग्राउंड पूछते हैं ना वो लोग, तो मे बी
हाँ, but ऐसा नहीं है, वो बैकग्राउंड इसीलिए पूछ रहे हैं कि आप साइंस बैकग्राउंड से हो कि नहीं हो. That is the reason they are asking. There is no specifically mention over that कि आप engineering background से हो तो pharmaceutical invention treat नहीं कर सकते हो, और pharma से हो vice versa. कि pharma से हो तो आप engineering invention नहीं ले सकते.
I have the one answer to this question, because I become a patent agent based on the section and the law which is given. I have gone through the each section, and I'm drafting the application not for the based on the engineering background, based on the fact. So if I'm qualified patent agent, so my application needs to be in line with the Patent Act, not with the engineering background.
This is one of the answers. This is one of the diplomatic answers.
But the thing is that we have seen that lawyers are not usually like going for drafting this thing. They also take support of law. You know, if a lawyer is drafting any application, he may also go for it then.
Madam, my
Lawyer
answer,
cannot file the application. No? Patent agent can do that.
madam, my answer will be, though I am not a subject matter expert of that field, yet by virtue of my background, that is engineering and industrial background, I can easily understand the invention and proceed further, satisfying the needs of the Patent Act.
Correct. Just maybe the answer. Just tell me the answer.
So, Murli, there is I'm totally like yes, I agree with you.
Because
They have to
engineering can
satisfy the
having the
patent
common
office.
sense, so we can understand the invention and draft in line with the Patent Act.
Correct. Okay. So we'll meet the next week. We'll conclude today's session.
Thanks, madam.
Thank you, ma'am.
Okay. Bye bye. Happy Sunday.
Thank you, ma'am.
Thank you.
Bye bye.